for indigenous peoples so that indigenous peoples will have the same inherent human rights that the rest of humanity already takes for granted. And so this UN Declaration with its 46 articles contains a very comprehensive framework, a standalone framework that all by itself creates a body of law for fully defining Native American and indigenous rights and meeting aspirations. The express goal of this UN Declaration is remedial justice, restorative justice, to rid the lingering ill effects of colonialism in all of the countries around the world that were former colonies, and to restore the human rights of those native peoples that fell by the wayside over the past 500 years during the era of colonialism. And the centerpiece of this new framework is the indigenous right to self-determination. And that's further flushed out as to what that means by all of these other 47 articles in the Declaration. But it stands on pillars of non-discrimination and equality. It stands on a pillar of a broadly defined right to culture. It stands on the pillars of indigenous lands, environmental protections, and the pillar of socioeconomic justice. These pillars and this legal framework also rest upon very just notions of justice, of democracy, of good government, diversity. These are stronger values, modern values that are far more just and the highest aspirations in the human breast, I guess you could say, far more than the dark values that underlie the law of colonialism. The only problem with this brand new legal framework is it's not self-enforcing. It's not legally binding. But rather it's simply a policy and a standard. It's got very strong persuasive and in some places legal power to it. But it must be implemented. These standards must be implemented by every nation into the domestic law and policy. So in the United States, it's very similar to the Indian self-determination policy that President Nixon articulated in 1970. He came forward with this dramatic break from the past and announced from here forward, it's our policy for Indian self-determination. But in 1970, it was simply a policy. It remained to be implemented across the land. And so that was the work of 2 generations of attorneys and tribal leaders to take that policy and implement it through strategic law development, litigation, legislation, agency changes. And it's the same way with this declaration. We have now, since President Obama endorsed the declaration, a brand new human rights policy that's technically already a part of the United States policy. But it's our task as tribal people to go forward and implement that policy into our domestic law here in the United States. And we stand at the very foot of that mountain, I think. And the ball, I think, is in our court to do that, to take up this challenge. with our visionary tribal leaders, with attorneys of a certain kind that can rise above the day-to-day work and serving clients to look at the bigger picture. And I think that that's the big paramount challenge that sits before our Indigenous advocates today. So I want to turn to looking at some of the implementation issues and the advocacy issue that I think sits before our advocates. And of course, Indigenous, the first question that advocates want to know is, where do we start? But I think that that answer to that question differs in every nation. We all have this legacy of colonialism, but each country, the facts and circumstances are different. Here in the United States, we can look to, as a starting place, it seems to me, James Anaya's report. As the UN Special Rapporteur, James Anaya came to the United States on a diplomatic mission in the year 2012, and in consultation with the government and Indigenous leaders, developed a report entitled "The Situation of Indigenous Peoples in the United States of America." You could go online and read that document. It's a fairly short document, but it's one of these kinds of documents that come along once in a great while as a harbinger of great change, sea change. If the recommendations that UN Special Rapporteur James Anaya, who's currently the dean of the law school at CU in Boulder, it identifies barriers in the United States to achieving these UN standards. And it goes on to give recommendations to all three branches of the federal government for fully incorporating these UN standards into our law and social policy. For the president, it says that the president should promulgate an executive order that directs all of the federal agencies to adhere to these UN standards in their dealings with Native peoples. It can be done with an executive order. Secondly, it asked the president to carry forward Congress's apology to Native Americans and carry that forward into a program of national reconciliation with our Indigenous peoples. As to Congress, the report asks Congress to curb its power, to voluntarily curb its plenary power over Native people. Big step for Congress to voluntarily curb its power. And it goes on to the courts and saying that the courts need to discard their colonial era doctrines for divesting Indigenous rights. These are sea change recommendations for our country. And so the question begins, how do we implement these recommendations as a starting place? And so our advocates for this next generation, we see the need for strengthening our Indigenous rights. We see the need to implement these UN standards into our domestic law and policy. And there's a need for our legal advocates to find ways to reform and strengthen the law, that is the legal framework for Indigenous rights. This is a very daunting task, And to do it, we have to rise above our day-to-day work to trying to look to the existing framework. because our existing framework is part of the problem. But thankfully, lawyers are trained for this kind of challenge because we're trained in law school to be problem solvers. Client comes in, has a problem, they look to the attorneys to help them solve it. So legal advocates are continually searching for the best forums, the best legal theories, the best remedies, and the best strategies, for presenting our claims, for meeting our clients' needs. And sometimes in that search, we find that the law is inadequate, or there may not be a good forum out there for our clients. So our search at that point entails changing the law and finding new and better forums for presenting our claims. And this is a proactive process called strategic law development. And it can be done on a discrete issue-by-issue basis, a discrete client-by-client basis, or it can be done on a large scale when we're confronted with a systematic problem. And such as overturning Johnson v. McIntosh, Lone Wolf v. Hitchcock, the Tehatun case, Ling case, the Smith case. These are daunting tasks, and they're not going to reform themselves, but they require what we're known as strategic law development. Our advocates need to be social engineers, very comparable to the legal campaign by African Americans to move from Plessy v. Ferguson, that was a Supreme Court decision in 1896, to go all the way to change that legal framework of racial discrimination to Brown v. Board of Education in 1954, which was a 58-year time period when the NAACP Legal Defense Fund faced bigger hurdles than we face today in that march to justice. There was no such thing as civil rights law. They had to invent it. They had no black attorneys. There were no law schools that let them into studying law. They had to take Howard University, which was unaccredited, and make it into a law school and invent civil rights law. They had to formulate a strategy, a litigation plan. They chose the courts for their battleground. It was the only forum they had, the great equalizer. Initially, they used the existing framework, the separate but equal doctrine of Plessy v. Ferguson, focusing on the protective features found in it, that the schools had to be equal. If they were going to be separate, they had to be equal. So they went under that equal side in their litigation. All the way to 1950, when finally they took that legal framework as far as they could go. And from that point forward, they could either continue to litigate on a school-by-school system, or they could change their strategy and mount a frontal assault on segregation itself, that it was inherently violates equal protection. And that change of strategy was made in 1950 when the stars were aligned and they made the march to Brown v. Board of Education in 1954. They found their hero in Thurgood Marshall, and when he went into court that day, he made a place in heaven for all public interest lawyers, I think, because he would not be denied. And I think that provides to me the There's a lot of good lessons that can be learned by a committed race of people for the long haul, to move from an unjust legal framework to a new framework. And we did that in part in the tribal sovereignty movement. As I close, we took the concept of self-determination and ran with it as far as we could go. Much like the NAACP strategy, we didn't challenge the legal framework along the way. We lived with the dark side, just like NAACP Defense Fund lived with the separate but equal doctrine all the way to 1950. They didn't turn on it and mount a frontal assault until they were at the point in their strategy when they could walk through the door. And I think we're the same way in our campaign since 1970, 46 years. We've come a long way. We've come as far as we can go. And now, to go any further, it seems to me we need to call upon our advocates to be social engineers, to change our legal framework and march through that door into the human rights era where true, robust, indigenous self-determination can be found that rests upon notions of justice and goodwill, human rights or human right foundation. So I think that's our challenge, and I think that the law schools, we need to get our advocates trained. It's not enough just to simply teach the holding in cases, our existing doctrines, without a larger vision of how to reform the unjust features, and we need to learn in the United States here the language of human rights, our young advocates that are coming up. Canada, they're already litigating quite heavily under this UN declaration. The last time I looked, 6 months ago, there were at least 19 cases brought by First Nations that rely upon this UN declaration. And these written decisions of the Canadian courts have begun a judicial discourse on the impact of human rights law for the First Nations. They have embarked on that journey. We haven't here in the United States. That challenge still sits before us to go down that road. So that's what I wanted to mention, to kind of issue a challenge, especially to you young attorneys here, you law students, law professors, colleagues, to raising our eyes, to a larger vision and begin focusing on notions of large-scale law development, which I think will bring us to that essential moment when we can all stand in the light of justice. Thank you.
Walter Echohawk, thank you for those fantastic words of encouragement, and certainly the need for us to look at the UN Declaration on the Rights of Indigenous Peoples as a core strategy for achieving self-determination. We are encouraging people to not run but rush quickly to the breakout sessions. And the session leaders, we are under a little bit of time constraint today, so at 12 noon we'd encourage you to break your session and encourage people to assemble at the foyer where we're going to do our closing event and to be with us. So thank you very much.